Time of day sentencing on probation violation. The defendant is present, represented by attorney Zachary Glaze. People are represented by prosecuting attorney Timothy J. Rieckowski. On May 11th of this year, the defendant entered a guilty plea to violation of probation, and probation violation report has been prepared by Mr. Nathan Licht. It's dated May 12, 2026. Mr. Glaze, have you and your client had the opportunity to review the updated report?
We have, Your Honor.
Any additions, deletions, corrections, or objections?
The only addition that it would make, there are no corrections to be noted, but just by way of update, it notes that he hadn't completed the alcohol class. He has at this point completed the alcohol class. If you have that certificate that he provided to you.
Okay, we'll note that in the report as well.
Thank you. And just so the court understands, he had had that scheduled for several months, and it was actually canceled by the program because they didn't have enough participants. So that's why it's really coming in here late in the game. Though it certainly could have been done earlier.
Understand. Also, there is a sentencing memorandum that the court reviewed as well.
Yes.
This matter. Do you agree with all that, Mr. Chilovak, regarding the report?
Yes, sir.
No additions, deletions, or corrections other than what Mr. Glaze has stated?
Oh, yeah.
Mr. Kocowski, any objections to the report?
No, Your Honor.
Thank you. Mr. Glaze, anything you'd like to say on behalf of your client?
Absolutely. So as the court noted, I did submit a sentencing memorandum, providing the substance of my argument. And I'm frustrated. I'm sure the court's frustrated as well. My argument is very similar to what we said the first time we were here. While I always appreciate when my clients hire me again, I'm not in the type of business where I necessarily want to see clients over and over again. And Brendan's one of those clients. I think our first case was resolved in a way that was certainly beneficial to him. I think it was appropriate. I think justice was served. And through that sentence, there was a punitive measure initially with some jail time, allowed to serve on the weekends, allowed to keep his job. He went through rehabilitation. Of course, had the first probation violation, a little more jail time that time, but still kept on HYTA status, and here we are again. And like I said, I'm sure the court's frustrated. I think at base, though, of course, the sentence has to do with rehabilitation and punishment. And as noted in my memorandum, he has completed sex offender therapy. The discharge from that program noted it was done with improvement. He complied with everything. Of course, his legal troubles subsequent to have nothing to do with sex offenses. So I think from the first sentence, that rehabilitation was successful in that sense. But obviously what we have here is an issue with respect for the law, respect for the court sentence, with Mr. Chilovak having come before this court twice now with OWI offenses. With the second offense, he's entered a plea, admitted responsibility in that. He's due for sentencing in Sanilac in the coming weeks. I certainly think the court would be well within reason and would be appropriate to impose a punitive sentence. And that punitive sentence necessarily might need to be more severe than the last. But I think that removing him from HYTA, I think would be too punitive, to put it frankly. That's not just a limited sentence of months or even a year and a half, which is being recommended here by the probation department as far as incarceration. That would be a lifelong punitive sentence. It would be a sentence of stigma for the rest of his life. I think that that would be a step too far, in my opinion. Certainly well within the court's ability to do that, but I would ask the court not to do that. If he needs to be incarcerated to really send a strong message, then by all means, then I think the court should do that. But I would hope, and I know what he would hope, that he would be able to remain on HYTA status so that he can come back from this, do what time he has to do, get alcohol treatment, and get that issue under control. Seemingly, that is the issue that remains. The sex offense issue, I think, has been addressed, and I don't foresee that as being a problem in the future. So I would ask the court to not follow the recommendation of PSI, sentence him to whatever punitive term he finds necessary, but to leave him on HYTA status so that he can continue to receive the benefits of that status.
Thank you. Does your client wish to address the court?
Yes.
Mr. Chilovak, go ahead, sir.
I would like to say that I understand what I did was wrong. I take full accountability for that. And I I understand I have an alcohol problem. I never meant to disrespect the court or, I apologize. I just hope that you give me what you see fit and I can look past it.
You're welcome. Mr. Rieckowski, anything you have?
Your Honor, I would point out to the court sentences a lot of individuals to HYTA and gives them that opportunity to not have a criminal record. And at times we'll get people that will come back and the court will revoke the HYTA on the first violation. The court didn't do that in this case. The court also looked at the circumstances and said, well, we'll give you another chance. But the end result is that he has two new criminal offenses while on HYTA. The first time the court initially, when he gave Mr. Chilovak HYTA, said 16 days in jail can be served on the weekends, even working with him because he had a job at the time. And then he picks up this violation, so the court gives him 60 days. And then from there, after he does his 60 days, now he picks up another offense. The bottom line is that it's not, the probation through HYTA doesn't say no sex offenses. It says no violations of the law. And he violated the law not once, but twice. And because of that, I believe that that is based on what the recommendation was from Agent Lick. We ask you follow the recommendations. I would point out that the recommendations are at the lowest end of the guidelines too.
A lot of times in criminal cases, there's always one side of the story. One side of the story typically is, well, you do the crime, you do the time. This is a violent crime, or this is a heinous crime. This is a terrible crime. And you have to be held accountable for it. And we understand that. The court understands that. It happens every day. But there's another side to the story as well. The other side to the story is maybe it's a youthful offender. Maybe he was or she was in a situation where the collective thought process was gone and you were just acting, whether it be on impulse or because of substances or just flat out just, for lack of a better phrase and no disrespect, brain dead. It happens. People make mistakes. And this court, along with other courts around the state, have been giving individuals opportunities to better themselves. And, you know, no one wants to be known as the hanging court or the strict court or this. Every case is different. Every single one is different. And the idea is to impose a sentence that not only sends a message, but looks at rehabilitation, looks at other factors to come up with something where at the end of the day, you learn from it, you move on from it, and you never do it again. And the underlying offense here is significant. And we have a very young man in front of the court. And so there are times that in cases like this, you have to look at the whole picture. You just can't look at a snapshot in time and just accept what one party says over the other party. You look at the whole thing. And this court has always believed in rehabilitation. The reason is, at the end of the day, again, the individual, let's be honest, the cost to the state in housing individuals like this, the burden upon law enforcement, the burden upon the community, the threat to the community, all this plays into account when a court has to fashion an appropriate sentence. And Mr. Glaze, on behalf of Mr. Chilovak, has done an excellent job in getting Mr. Chilovak in the right direction. He made a terrible mistake. But as a result of that mistake, there was some learning behind it, and he was given an opportunity. And that's what Holmes Youthful Trainee Status is all about. The idea of Holmes Youthful Trainee Status is to take young offenders who make dumb mistakes, no disrespect, dumb mistakes, learn from them, be productive, and move on. And as Mr. Rieckowski stated, this court does it a lot for youthful offenders, first-time drug offenders as well. And the reason behind it is, you know, we can just throw them in jail or prison, throw away the key, but what's it helping? when that person is released from a jail or released from a prison facility, is there anything that helped them so that they don't reoffend? In this case, the probation violations are unrelated to the initial charge and plea that was entered in this case. And from the court's perspective, above anything else, this court does not like the idea of yanking someone's HYTA or 7411 status, whatever it is, even diversion on domestic violence cases. It's not happened just once, but it happened twice here. And both violations involve substance use. And on one hand, because it's unrelated, there's a possibility, well, maybe because it's unrelated, we should continue this. But here's the problem with that. What does this court tell other people who get HYTA status or 7411 status and they toe the line and they work their tails off and they sit back, learn from it, I'm not doing that again. Now, in cases like this, if it had been merely consuming alcohol, that's one thing, but consuming and driving, that's a violation of the law. And the court cannot turn a blind eye to that, sadly. And the court, frankly, in this case and other cases, is disappointed. I'm disappointed. Personally, I'm disappointed because I don't want a youthful offender who's made a dumb mistake, no disrespect again, to face incarceration, lifelong stigma based upon the conviction, and a conviction, frankly, that is the scarlet letter, so to speak, upon an individual when they try to turn things around, be productive. But what's a court to do when you're given all these chances? And it's disappointing. It saddens me. It's sad to me personally because I could be on that side. I could be on the other side of the podium. And frankly speaking, probably after the first time for me, I would probably be in a different state as well. But it's fish or cut bait. And at this point, the court has extended as far as the court can extend. It will be the sentence of this court that the HYTA status is revoked, sadly. Criminal sexual conduct, third degree conviction enters. Unsuccessful discharge from probation. He's to register in the Michigan Sex Offender Registry Act, comply with all requirements of the act and all the rules pertaining to it. And here's the difficult one. Defendant is committed to the Michigan Corrections Commission, placed in their custody for a period of 15 months to a maximum of 15 years, credit for 85 days previously served. Second, my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, the court will assign counsel form of public expense. These conditions will seek questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Mr. Chilovak, I'm sorry, but the court has to do what the court has to do to be fair to everyone. And at the end of this, after you serve your time, I hope that you learned from this, and I don't want to see you in this building again. No disrespect again. I wish you the best.
Yeah, just a quick question.
Go ahead.
Does the court, one of my requests that were, if incarceration were to be a sentence, that you would sentence them to some correctional with other private inmates, does that have to be placed on the record? Is that something the court considers? Or is that something that is a matter of course?
I think it's a matter of course. And I think that would be part of the oath.
Okay, and does he go into custody today, or would you like to report?
Today, reports immediately. Remand in the custody of the sheriff. Thank you. People of the State of Michigan versus Cassandra Rose Montgomery, 2670-470 FH, time and date set for arraignment. The defendant is present, represented by attorney Michelle Varsiv. People are represented by prosecuting attorney Timothy J. Rieckowski. Ms. Siv, have you received a copy of the information that's been filed? Have you and your client had the opportunity to review it the way for reading as well?
Yes, all the above.
Appears that there's a plea agreement in this case, correct?
That is correct.
Ms. Montgomery, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes, ma'am.
Thank you. Mr. Rieckowski, would you please state the terms of the plea agreement on the record?
Yes, Your Honor. Offer is that Ms. Montgomery would plead no contest to the charge in count 2. People agreed to dismiss count 1. The plea would be without habitual offender notice. Parties agree or stipulate to a guideline range of 12 to 30 months. And Ms. Montgomery agrees to pay full restitution.
Ms. Siv, is that your understanding of the plea offer?
Yes, please, Your Honor.
Ms. Montgomery, is that your understanding of the plea offer?
Yes, Your Honor.
Do you wish to accept it?
Yes, Your Honor.
Are there any other terms to the offer that we've not covered on the record?
No, Your Honor.
Ms. Siv, do you agree?
I agree.
Mr. Rieckowski?
I agree.
Are you on any term of probation or parole?
I am
Which one?
on probation.
To this court?
Yes, Your Honor.
Okay. You understand this could have an effect on your probationary status?
Yes, Your Honor.
And you discussed that with Ms. Siv?
Yes, Your
Do you understand that?
Honor. Yes, Your Honor.
And you wish to move forward despite that fact, correct?
Yes, Your Honor.
Have you had sufficient time to speak to Ms. Siv about all of this?
Yes, Your Honor.
Do you need any additional time to speak with her?
No.
Is there
No.
any, I'm sorry, go ahead.
I said no, Your Honor.
Okay.
Sorry.
Anything affecting your mind or brain, making it difficult to make important decisions?
No, Your Honor.
You have a clear mind.
Yes, Your Honor.
You're charged with assault by strangulation, which is a felony carrying a maximum prison sentence of up to 10 years and or a fine of up to $5,000. You understand the charge and maximum sentence that can be imposed?
Yes, Your Honor.
All right. Understanding that, Ms. Siv, how does your client plead to the charge count 2, assault by strangulation, on or about May 10 of this year, bad acts here on county mission?
She pleads no contest, Your Honor, and that is due to the potential civil liability.
Any objection to that, Mr. Rieckowski?
No, but I believe the count 2, when you read the language, is assault and great bodily harm less than murder, and the other one was strangulation.
I apologize. You are correct.
They're the same statute, so the title is the same as the court had read.
You are absolutely correct. So it's assault with intent to do great bodily harm less than murder. You understand that charge in the maximum sentence?
Yes, Your Honor.
And no objection to the no contest plea, Mr. Rieckowski?
No objection, Your Honor.
So is your plea no contest?
Yes, Your Honor.
Court is in receipt of an advice of rights form. It has a signature on it dated today, and it has a printed name of Cassandra Montgomery. Did you sign this document, Ms. Montgomery?
Yes, Your Honor.
Now, before signing, did you read it over?
Yes, Your Honor.
Did you also go over it with Ms. Siv?
Yes, Your Honor.
Do you understand the rights contained on the form?
Yes, Your Honor.
By pleading no contest, you're giving up all these rights. Do you understand?
Yes, Your Honor.
It means you will not have a trial of any kind, nor have any opportunity whatsoever to contest your guilt. A no contest plea will come out to you admitting your guilt, bless you, and all that remains after today will be for you to sentence.
Yes, Your Honor.
If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice.
Yes, Your Honor.
Other than the terms of the plea offer outlined by Mr. Rieckowski, has anyone promised you anything such as leniency to get you to plead no contest?
No, Your Honor.
And you understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing the sentence. Do you understand that?
Yes, Your Honor.
Does anyone promise the court will be easy on you?
No, Your Honor.
Does anyone threaten you to enter this plea?
No, Your Honor.
Be your own free choice.
Yes, Your Honor.
Court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that?
Yes, Your Honor.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days after conviction and sentence.
Yes, Your Honor.
Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand that?
Yes, Your Honor.
There was also mention of a proposed stipulation between the parties of 12 to 30 months. You understand the parties, the prosecutor and defense may agree on that, but at the end of the day, the ultimate sentence still rests with the court. The court does not have to follow that. You understand?
Yes, Your Honor.
Do you have any questions of Ms. Sipp? Any questions regarding any of your rights? Court is in receipt of People's Proposed Exhibit number 1, which is Bad Axe Police Department Incident Report 26-01110. Ms. Sipp, any objection to that admission, that document for purposes of fact?
No objection.
All right, court will review it. Court's had the opportunity to review Incident Report 26-1110. And it indicates that there have been a fracas between the defendant and the victim in this case. I can state victim now. And during this incident, according to the report, the defendant had grabbed the victim by her hair, dragged her out of the house into the front yard, started to punch her in the face with her fist repeatedly, tried to reason with the defendant, not fighting her, would not fight her. And that the defendant was throwing punches at her face whenever she could. ER reports the same relative to injuries. Bruising behind her ears, reported ringing in her ears, bloody red eyeballs. Then the photographs, which clearly speak for themselves. Mr. Rieckowski, you aware of any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Sit.
No, yeah.
Has the court complied with the court rule concerning police, Mr. Rieckowski?
The court has.
Sit.
Yes, I have.
Ms. Montgomery, there is no agreement made by this court concerning your plea with the final sentence. Is that accurate? Sit.
I agree.
Mr. Rieckowski?
Yes, Your Honor.
Court will accept the plea. It's done freely, it's voluntary, and understanding. A sufficient factual basis has been established by review of Bad Axe Police Department Incident Report 26-1110, contained in People's Exhibit 1. A sentencing day. Consider looking at August 30th.
That works for her. I would ask, because there is, Ms. Montgomery is supposed to be sentenced for a probation violation on July 20th. I would ask that it's supposed to be heard on the same day.
Any objection, Mr. Rieckowski?
The question would be for probation. Could they do that within that time frame?
I'm asking the August 31st date, you may, at least with a new felony, I have many.
It sounds like she wants to adjourn the probation violation
Oh.
until August.
I'm fine with that if that's the case. I thought.
Right.
moving
Yes,
up.
yeah, that is.
You're okay with that as well? Then we'll adjourn the companion file as well. August 31, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report be prepared, provided to both counsel and court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the court no later than 7 days from sentencing. Also notice to the probation department. Ms. Montgomery must appear in the courtroom at time of sentencing. Any supporting documentation may be submitted to the court no later than 7 days from sentencing. Any objection or written response is filed 3 days thereafter. Mr. Rieckowski, your position on the current bond set in this matter.
Bond was set in the district court at $50,000 cash or surety. Does the court have a different amount?
That's what I have. Is it? Has that been posted?
Yeah, it has been posted.
50,000 cash surety has been posted.
We haven't been made aware of any violations, at least at this point, so if it's posted, we'd ask it continue.
Okay. Is it-
That, I just wanted to tell you where, I'm supposed to get a total of 150. Because I
You're a
believe,
bonds person, I'm assuming.
yeah, yes, I'm, right, yes.
So they posted the entire amount. And the
I'm sorry, you're right. I'm combining the probation violation to this one. I apologize. So yes, it is up to 50,000 for this.
Okay. Bond will continue as previously said. Anything else for the record?
Okay.
That'll conclude the proceedings. Off record. People, State of Michigan versus Alexander Michael Klosk, their file number 257246FH. Klosk is in the courtroom represented by Attorney Justis Riskey. People are represented by prosecuting attorneys J. Kocowski. On May 8th this year, Mr. Klosk pled guilty to violation of his probation. Ms. Mandy Alexander has prepared an updated report dated March 2nd, 2026. Ms. Riskey, have you and your client had the opportunity to review the report?
Yes, Your Honor.
Any additions, deletions, corrections, or objections?
Okay, and to be completely transparent here, I obviously was not the underlying attorney on the 2022 or the 2025, but it's still important that the corrections are made. So if we go back to page 1 of the June 16th of 2025, on page 1 where it states psychiatric history, I would argue that he has, he's been diagnosed with ADHD since 2006.
Are you talking about the original pre-sentence?
Original pre-sentence. Well, I have, when I was sent all of this, I was provided the 2022 and the 2025.
Correct.
So I'm going back to the 2025. It just knows that there was no psychiatric history, and Dan would argue that there wasn't because of that. And then if we go to the 2022, if we.
Well, time out for a second on that one. No, don't be sorry. It wasn't objected to beforehand, but the court will ask that it be added into the
Okay.
updated probation violation report
Thank you.
to reflect that he's diagnosed with ADHD.
Yes, he was diagnosed with ADHD in 2006,
So you just add that somewhere in the document.
and he's taken, and my other correction was.
I apologize, I'm looking at, and we don't have anything in the violation report per se. That's information that's on the PSI.
Right. I would ask that you put that in. You can even add it into the evaluation and plan. Just add a line indicating that he was diagnosed with this condition, ADHD, and he's being medicated for it.
Okay, and so that was my other one, was back in 2022 on page 8 was he was diagnosed in 2006. He took various types of medication, which ended in January of 2020. And, obviously we're stating it for the record. I wasn't the attorney of record, so I'm sorry at that point in time. And I just want to make sure that everything is correct.
Anything else?
Okay, now I will go back to the actual probation violation
Okay.
report. On page 2, under treatment programming, I just want to note that he is on the Rieckowski shot. Varsiv, sorry. Varsiv.
Here's $1 million question. How do you spell that?
Vrixadi. I can spell it, I can't say it.
All right, we'll add that. Anything?
Yes, then on page 4, in the 5th paragraph, in the bottom, in the last sentence, when it's saying the defendant was released unsuccessfully from the TRICAT program, but we believe that to be untrue. He successfully completed that program and then was transferred to Silver. So.
And I have no information on that.
I apologize, which part was that in?
5th paragraph of the last line, unsuccessfully from TRICAT program.
Page 4?
4 of the probation violation.
The very last line. Where it says unsuccessfully, they claim that he successfully completed it. Did he?
That's correct, yeah.
Okay.
And I figured it was just a typo, but I just wanted to make that. Okay. Then there are 2. I have some credit that I will bring up, but also I have the same paragraph that I had mentioned that it's actually in the 5th line down. when it's talking in December 2025, the no contact order. I would ask that this entire sentence be stricken. I mean, that issue was kind of been litigated over and over. There was another attorney involved, and we were never able to get the actual information as to why this no contact order amendment of probation was just handed over to the court without any explanation. I mean, this is the first that we were given that information. We don't believe it to be true, and I would ask that it be stricken.
Mr. Rieckowski.
The question is there a no contact order at that time that was signed? And there was. So I think it's accurate.
I mean, and you can put that it was implemented, that I guess between that, but then I would ask that after that, due to the Regional Drug Court Committee finding an unhealthy co-defendant relationship, I mean, there wasn't any hindrance during TRICAP to successfully complete that.
I understand, but that's where that came from. So it's going to stay in over objection.
Okay. I'm gonna move to the credits. So based off of my calculations, yes, I do have that, the February 20th to the 21st and the initial arrest with 1 day of credit. I also have the, April 28th through, June 16th of 2025, when I was revoked to sentencing at 49. But I also have that, August 4th through August 22nd, he was arrested for a drug court violation, and he was held for 18 days prior to his transfer at TRICAP. And then there was, and as noted in the report, it's dating February 12th through May 10th, but he was actually lodged on February 9th, so we would argue that that credit should be 30 days. And then he was in TRICAP from August 22nd until January 22nd, which was an additional 150 days. I mean, he wasn't free to leave. We'd argue that he should be receiving credit for that as well, which would make my calculation 248 as opposed to the 77. But I understand how they would not have some of that because he was lodged into SCOLA. So that's where like the difference comes from, if that makes sense.
Anything from probation?
So let's go back to the August, the violation he was lodged on was, that was sanctioned through, drug court. So I wouldn't have given him credit on that, and then he was sanctioned to the TRICAP programming. I also wouldn't have given credit on that because that was sanctioned through their program. That's why I would never give credit on that.
So is he not entitled to it, or is he entitled?
I guess that would be at the discretion of the court, but I don't think that he would be entitled on our side because that was a sanction through drug court. That's what he was sanctioned.
My recollection was not though, because when we had I represented him on the August 2025 violation in the Regional Recovery Court, where he was sanctioned to TRICAP, and when we waited, and then we had to come back here, where he was represented, I do believe, by Mr. Murkowski, where then he was sentenced to 30 days in jail at TRICAP. So I would still argue that he would receive credit for that. It was not, I mean, because in order for you to go to TRICAP, you have to be lodged within the jail for 14 days to make sure that you're, clean to go. You can't just, you're not free to walk away. You're going directly from the jail to TRICAP. I mean, and that was order 2 when he had that probation violation there.
Mr. Kocowski, your position?
As it relates to the time that Mr. Riskey's asking about with the holding him until TRICAP, I agree that he was being held and should be credited for that. If there's violations that happen through drug court, it's no different than the court having a probation violation here and sentencing a person. They would get credit for it. The only question, I guess, is TRICAP itself, that program, does the court give him credit for that? Some of the other things, I don't have the numbers. Ms. Riskey might have the numbers, but as it relates to him being held, he should be credited for that. If he's serving a time where he's being held while a violation is pending, he should get credit for that. Those are all things that, regardless if it's drug court or here, those are incarceration related to this case. And this probation for TRRDC was through this case, so it should be entitled to that credit.
Okay. All right.
Would you like those numbers again, Your Honor?
Well, it appears to be 248.
Yes, that is my calculation, yes.
Mr. Rieckowski?
And that's if you give him credit for the TRICAP, which we have, I guess, it's court
So
discretion.
the only difference is that what I already have is where yours says February, like the third one down.
Because he was actually was picked up on the 9th, so it's 3 extra days here. And then the 18 days that he was held from the arrest to TRICAP. And then while he was in TRICAP to.
Rieckowski, any other comments?
No, Your Honor.
Anything else from probation?
I will just need the dates again from I have it, I believe, in the file somewhere for the TRICAP.
I can give it to you real quick.
Go ahead.
Okay, so I have August 4th, 2025 to August 22nd, 2025 was the arrest transfer to TRICAP at 18 days. Then I have from TRICAP at 8/22 to January 22nd and 26th at 150. And then the February of 2026 to March of 2026 is actually 30 because he was picked up on February 9th, not the 12th.
Anything else?
No more corrections. Now we're getting to the allocation.
No, that's okay. I just want to make sure we have everything covered.
No, and I appreciate your patience.
Mr. Klosk, anything else other than what your attorney is?
No, I think we're good, but thank you.
Mr. Rieckowski?
No, Your Honor.
Riskey, what would you like to say behalf of your client?
There is so much I want to tell you, so I will apologize now for being long. I know that that's just what's going to happen. You know, back in August of 2025 is when I met Alex for the first time. Back when we had a scare, I mean, because we're not gonna shy away from these issues here, because I know it's gonna come up, you know. Yes, we had an issue back in 2022, and unfortunately, sometimes, and I think a lot of us in this room understand that what happens with recovery is it's not linear, it's not always easy, and sometimes relapses happen. Sometimes we think we're good, and then life happens to us, and you realize you're not good. And so, yes, we did have that issue back in 2022, and here we show back up in 2025. Alex is very well aware that he ruined a really great opportunity that this court gave him with HYTA. He knows that. So then in 2025, he was, you know, given the opportunity of, you know, all right, let's try recovery court, because treatment courts work. I'm a big proponent of treatment courts. I think many people know that I worked with recovery courts for a very, very long time. It's something very near and dear to my heart. At that point in time, I was still a member of the team. I was, you know, excited that, okay, we were gonna hopefully make some changes for Alex, and he was gonna be able to learn all of these new things. However, it didn't go the way that we wanted it to. And we had that scare back in August of 2025. And he acknowledged that, he admitted it, we were lodged. I came and I saw him, and I was pretty blunt. This is what's gonna happen if you don't do this, so I think you need to do it. In the back of my mind, I was also a little nervous because Alex, who has not had exposure to, unfortunately, a lot of the individuals that attend TRICAP, because the problem is that sometimes these resources are out there and they are very good for people, but sometimes other people take advantage of those, and so they're there to avoid consequences and not really focus on and do the work. I see it every day. Sometimes you go and you learn tricks and things that, you know, you don't need to be learning. Sometimes you're with individuals who have more of a criminal mentality, and it's not very good. And the reason I mention that is because Alex has had difficulties in his life. You know, yes, he did graduate high school. He also attended special education. We had, you know, a couple head injuries from when he was a younger child. There are a lot of things that make Alex a very unique individual who, unfortunately, doesn't always think like everyone else does. So I wanted to bring that to attention. And so, yes, he went to TRICAP and he did well. There were some challenges. It was an adjustment. You have to be with a different, group of people and dealing with so many, differences just among the population, because I mean, there are people who go to TriCap from all over, but he still successfully completed it. And I think that it's important to note that then in January, we come back to, okay, now you're gonna go to sober living, which again, sober living can be great for a lot of people. I see it change lives every day, but it also can, again, be used as a crutch sometimes. And unfortunately, Alex goes from being in this great structured environment where he was doing great, he was driving, he gets moved to Carroll, which is very far from where he lives, far from everything he knows, everyone he knows, with no resources, no vehicle, no money, no job, no nothing. It was difficult. It wasn't something he wanted to do. He wanted to be able to go home. And so we recognize that, yes, there were some things that occurred. And again, then what happens in January when he comes back? He's met with a large group of people who he was honest with, who were bringing alcohol and different prescription medications into the sober living home. And, you know, he acknowledged those probation violations. So again, we're not trying to run away from that. And then, okay, fine, there's no contact order was put into place. I don't love it. As a parent who has adult children, you know, my kids are pretty attached to me and they still look to me for guidance and maybe on some simple things they shouldn't. And I don't, you know, I'm sure some people would have some comments to say about it too, but just because we have a very close relationship or a very helpful doesn't make it a codependent relationship. You know, we have this PSI that says that, oh, they exhausted all of the efforts, so he could be a productive member of society. Well, and maybe because Huron County could only do what Huron County could do when he was sent over to Carroll and then things became like it. I don't know. But again, Alex is doing so great. From when I met him back in August of 2025, I can't tell you, the light in his eyes is back. He is kind. We have really good conversations. He is funny. He is thoughtful. I got busy a month ago as we're trying to, you know, discuss this stuff. And he's always, you know, making sure that it's a good time for me, and he thanks me for every little thing I do, even though I'm just doing my job. I was sick last week. I know that anxiety leading up to this has been really heavy on him, but he's been patient because he knew I wasn't feeling well. And he's just shown such tremendous growth. Since his release from incarceration back in March, he got back into his services. He sees Kim at HBH bi-weekly. He does not miss. He is very faithful, and he is being open and honest and really working towards his goals. He's also trying to make other goals. Like, he's making sure that he is scheduling and attending all of his appointments. He's actually got therapy this afternoon with Kim. He is on that shop that I had mentioned earlier, the one I can spell and not say. And he has his follow-up with that on Wednesday. He has his psych appointment on Thursday. He's been faithful and consistent in that, maintaining all of his medications, taking them as prescribed. He's going to peer 360 meetings. He tries to hit one every day if he can, but at least every other day. He even has an interview later this week for a dishwashing position for a local restaurant. Like, we are making moves and we are doing things. And so while I understand the recommendation, I don't think that, especially given with 240 days of credit, just here, let's just throw you a little bit of jail and then be done. I think what would be better for Alex is continue probation, to let him continue to prove to you, to prove to this court, to prove to himself that he can do this, and that he stumbled along the way, and it wasn't the way that we wanted it to happen, and he had the opportunities, and they could have went better, could have, but he really is, he's so focused and he's so driven, and I know that he is finally committed wholeheartedly himself, because he wants it for him now. It's not to make anybody else happy. He knows that he deserves to live a better life, and he is going to do it. And, you know, it's unfortunate that he didn't get to complete recovery court. I get that. But as someone who has been on a treatment court team for a very long time, sometimes our biggest successes are individuals who needed that harsh reality of, you're not ready now. And you know what, maybe he wasn't back in January, but I tell you, Your Honor, he is now. I am so proud of the man that he is now. I am so proud of his hard work. We would ask that you obviously give him credit for the 248 days. Again, I mean, he's doing all these things. He's had 0 positive turns. He's had 0 issues on his pepper. He's reporting as directed. He's doing all that he needs to do. We'd ask that you continue him on probation. And if you feel the need to have any type of deal, that it be deferred for performance, because Alex wants this, and Alex is gonna continue to prove himself each and every day.
Klosk, is there anything you'd like to say?
Yes, Your Honor. I don't think there's been enough, I don't think, sorry about my keys, I didn't get to put them in today because I think we weren't ready. But, no, I think the time is now. The time starts now for me to walk forward in a line that never goes back, and is to get on that mode, to work, go home, sleep, repeat. I don't need the extra stuff, I don't need to do the extra stuff. God forbid, I've done the extra stuff, look where it's got me. I need to stay focused, I need to stay on track, I need to stay motivational, driven by me, not anybody else. Nobody else is gonna tell me, yeah, come do this. I've learned that, I've seen that, I've tried it, and it got me nowhere, except here, in jail, almost dead. So, what I'm saying to you today is because of that, I've had to find my way. I've had to dig down deep, I've had to come to my senses to realize, who am I? Who are you gonna be when you grow up? Who do you want to be when you go forward in life? You want to be somebody that remembered by, well, an addict, a drug user, whoever. Or do you want to be remembered by somebody who actually gave a crap in this world? Because I know I try, and I try every day. But I'm trying. That's the main part, I'm trying. That's all.
Mr. Rieckowski, we have.
Your Honor, I look at it as 2 different choices for the court. One is just to give the balance of the year and end probation. The other is to continue probation, maybe some jail time, but to continue on probation absent the rules that have already been completed, such as no recovery court anymore, because that's been done, and TRICAP. I'm talking about the original terms of probation. I know that probation has done their best to continue on with things and monitoring. And I think that's why their recommendation is what it is. I've sat on the recovery court and I've seen Alex before. He has great periods of compliance.
Yeah.
And then we have something that goes off track. I can think of one where he was at one of the meetings, everything's going great, we're doing well. And then 2 days later, we get the information that he had used again. And that was disappointing. You know, I would lean towards continued probation myself with whatever the court would fashion for a sentence from the jail time, because the court is aware that he didn't complete recovery court. So we would ask for some incarceration time as it relates to that, continue with probation with the rules that have already been set. I think it's 3 years probation, so it's another additional 2 years on probation at this point. Does the court have any questions for me?
I don't, thank you. Well, this has been a work in progress. And Mr. Klosk has been given opportunity after opportunity to attempt to pull out of a very bad situation, including TRRC. And I'll never forget when I think it was a probation violation. The court ordered initially the TRICAP program, and there were groans in the back of the courtroom and from former counsel saying, no, you don't have to do that. And the court listened to that and didn't give it the first time. And if there's a mistake there, I think that's the court's mistake. I should have stood by my original decision for TRICAP. The reason the court states that is because we're trying to find every alternative measure other than locking you up there or in a prison facility. This is use of a controlled substance. Possession of a controlled substance. A nasty one, methamphetamine. I've said before, as a former criminal defense attorney, I lost a client to a methamphetamine case because he was brutally murdered. One, never forget that. Number two, just recently, I had an individual who's a close friend of mine. We played polka music together for years in a band in Ortonville. Name was called Dynabrass. And Tim, I read just last week, lost his life to substance use disorder. He died. He was a former high school teacher, band teacher. He was, after he was having issues with substances, he had gotten into sales, automobile. Excellent, just the most wonderful person you'd ever meet. And he's dead. He's dead because of this poison. And I have said it in this case over and over and over again regarding how bad these substances are. And the court did that not only to scare, but out of support, out of just a warning, anything. And you know, it's real easy, like I said, to sit behind the bench and say, you do this, you do that, you didn't do this, you didn't do that, you go. That's real easy for the court to do. Lost another musician friend to substances. Name was Paul. I appreciate that. And just out of the blue, individuals who are so successful, educated, and they fall to these substances. And let's be honest, Mr. Klosk, you were very close to being on the obit list. And what your parents went through, I couldn't imagine. By the way, the court order relative to that was from the TRRC program, and the court adopted it for your own benefit, because they know you better than I do when it comes to the treatment program that was provided to you. Sadly, you didn't complete the program. You did, though, complete the program in Saginaw, which is great. And you know, I understand sometimes you learn tricks and all that stuff, but and other ways of trying to beat the system. Problem is, all you're doing is cheating yourself. And probation is probably at wit's end. They've had enough. That's why they're recommending just let him serve his jail time, unsuccessful discharge, and move on. Court also notes that monetary obligations have been next to none for being paid to the court. Matter of fact, at the time of sentencing, $398 was owing, and all that's been paid so far is $17.37. So, you know, rather than the fun stuff and all that, it's time to grow up. Easy to say. Easy to say. No, you've had an opportunity, Mr. Plaster. I think it's too easy to put him in jail. I'm going to continue him on probation with the same conditions that were previously ordered. However, he is going to be remanded to the custody of the sheriff for at least 3 days. He's going to serve 3 days in the county jail for violation of his probation. Court notes that there is 248 days credit, but he's going to serve 3 days forthwith. No work release, no PA 511. But understand, Mr. Klosk, you come back before the court again. Guidelines don't apply. Your guidelines are 0 to 17 in this case, which means 17 months in prison. So you need to follow through. Easy to say, but you have to, because as I said before, there are only a couple of other options available, and none of them are good options. I do need to inform you of the right to seek leave to appeal. If you're financially able to provide counsel, your court will assign counsel for a public expense. You are to initial the receipt questionnaire form requesting the assignment of counsel. both of which must be executed under oath and filed in the clerk of the court within 42 days. As a matter of fact, he's still county appeal as well, correct?
No, that's still pending. now.
Still pending, okay. So that's another thing he's going to have to contest.
Your Honor, I'm just asking, so because we have therapy this afternoon, we have, his MAT follow-up on Wednesday and psychiatry on Thursday, his report on Friday. I think he's working for the weekend. I just,
Position of the people,
We leave it to court's discretion.
Friday morning, 9 AM.
Friday morning, 9 AM,
Thank you, Your
absolutely.
Honor. Thank you.
I just, I don't have to wait on some of those appointments, but we would do whatever we needed to do.
We'd like to matter of people of the state of Michigan versus Shona Lynn-Guseth, file number 267466FH. Ms. Guseth is present, represented by Attorney Elizabeth P. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Rieckowski. This time and date set for arraignment. Ms. Weisenbach, have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity to review it? You waive the reading as well.
Yes, Your Honor,
Appears there may be a plea agreement. Is that correct?
that is true.
Ms. Guseth, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Thank you. Mr. Rehabilitation, would you please state the terms of the plea offer on the record?
Yes, Your Honor. Ms. Guzzo may plead guilty to the charge without habitual offender notice. She agrees to pay full restitution.
We have a restitution amount in mind, Mr. Rieckowski, if you know.
Offhand, I don't.
That's okay.
Report.
That's okay. Ms. Weisenbach, is that your understanding of the plea offer?
It is.
Restitution amount, Your Honor, $1,295.42.
Thank you. Did you hear the terms of the plea offer outlined on the record just a moment ago?
Yes,
Is that your understanding of the plea offer as well?
yes,
And you wish to accept that plea offer?
yes.
Are there any other terms of this plea offer that we've not covered on this record?
No.
Ms. Weisenbach?
Agreed.
Mr. Rieckowski?
Yes, sir.
Okay. Ms. Guzzo, are you on any term of probation or parole?
No.
Have you had sufficient time to speak to Ms. Weisenbach about this?
Yes.
Do you need any additional time to speak?
No.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No.
You have a clear mind?
Yes,
All right. In the information, you're charged with the crime of embezzlement, agent or trustee, $1,000 or more, but less than $20,000. That is a felony, carrying a maximum prison sentence of up to 5 years in prison and or a fine of up to $10,000. You'll also be subject to court costs, state minimum fees, crime victims' right fees, probationary fees, or all of that. Do you understand the charge and the maximum sentence? Understanding that, then, Ms. Guzzo, how do you plead to the charge of embezzlement as an agent or trustee on or about October 27, 2025 in the city of Caseville, County of Durham?
guilty.
Ms. Guzzo, court is in receipt of an advice of rights form, and it's dated today's date, has a signature on it, and the printed name of Shona Guzzo. Did you sign this document, Ms. Guzzo?
I did,
Now, before signing it, did you read it over?
I did,
Did you also go over it with Ms. Weisenbach?
I did.
Do you understand the rights contained on the form?
Yes,
By pleading guilty, you're giving up those rights. Do you understand that?
yes,
It means you will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. And all that remains after today will be for you to be sentenced.
yes,
If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. And you'll also be giving up any claim this plea is not of your own free choice. Other than the terms of the plea offer outlined by Mr. Kocowski, has anyone promised you anything such as leniency?
No.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence.
I understand.
Has anyone promised the court will be easy on you?
No,
Has anyone threatened you to enter this plea?
no,
Is this plea your own free choice?
yes,
Court costs are due and payable at time of sentencing unless there's good cause. Are you aware of that?
yes,
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence.
Yes.
Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand that as well?
Yes.
Ms. Guzet, any question regarding any of your rights?
No.
Any questions of Ms. Weisenbach?
No.
Ms. Weisenbach, you wish to establish a factual basis?
Yes, Your Honor, thank you. There was a time you were employed at a restaurant in Casey. What was the name of the restaurant at that time? Okay, and on or about October 27th, there was an event in Casey, correct?
Yes.
That was October 25th, correct? It was Saturday, right?
Yes.
Okay. So on that Saturday, the Wooded Island is actually pretty much at the start of the Witches Walk, so a lot of people gather there, right?
Yes.
Which is an opportunity for staff to go out to the crowd and offer drinks and things, right? And is that what you did?
Yes.
Okay, so you were working for Wooded Island, waitressing?
Yes.
Okay, and you were responsible for selling beverages, serving the beverages and collecting the payments for them, right?
Yes.
And did you turn in all the payments at the end of the event?
No.
Did you keep the money?
Yes.
Was it your intention to keep that money?
Yes.
You understand that you were working for, you were an employee of Wooded Island at that time. You took that money for your own use, having no intention of giving it to the principal, the owner of the business, right?
Yes.
Was it a value of more than $1,000 but less than $20,000?
Yes.
Okay. And Caseville, Michigan is in Tarrant County, correct?
Correct.
And nothing further.
Any objection to factual basis?
No objection to the factual basis. Can I have a moment with Ms. Weisenbach?
You may.
May we approach?
Yes. All right, we had a brief sidebar, and Mr. Rieckowski, you wish to place anything on the record?
Yes, Your Honor. Based on a note that we had for a pretrial conference summary form at the time of the waiver of the prelim, the offer actually is that Ms. Guzet can plead to the charge. People would agree to a 1-year delay of sentence. During that delay of sentence, she would pay off all the restitution, which we put that amount on the record. And if that's paid in full and all the court orders are followed, upon the successful completion of the delay of sentence, the conviction would enter as embezzlement 200 to 1,000.
Ms. Weisenbach?
Yes, it appears that Mr. Rieckowski and I are looking at the same initial offer when we were starting this case this morning. Thank you.
Computers are a lot different than paper files, aren't they?
Yes, Your Honor.
I would agree. Matter of fact, we're in the process of transforming here shortly as well to my file, which would be interesting, to say the least. All right, Ms. Guzet, is that your updated understanding of the plea offer?
Yes.
And you wish to accept it?
Yes.
Any other terms to the plea offer that now that we've not covered on the record?
No.
Ms. Weisenbach?
Agreed.
And Mr. Rieckowski?
Agreed.
And you wish the court to accept this offer, correct?
Yes.
And because you wish to accept it as well.
Yes.
Mr. Rieckowski, any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Weisenbach?
No.
Has the court complied with the court rule concerning pleas, Mr. Rieckowski?
It has, Your Honor.
Weisenbach?
Yes.
Ms. Guzet, there's been no agreement made by this court concerning the plea and what the final sentence will be. Is that accurate?
Yes.
Ms. Weisenbach?
Yes.
Mr. Kocowski?
Yes, Your Honor.
Court will accept the plea. It's done freely, it's voluntary, it's understanding and accurate. There's a sufficient factual basis. We will schedule sentencing for August 3/1, Ms. Weisenbach, if you're available.
Yes, thank you.
August 31st will be sentencing, 2026 at 9 a.m. Prior to sentencing, court is ordering a pre-sentence investigation report. Be prepared, providing both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court and to the probation department no later than 7 days from sentencing. Ms. Guzet must appear in the court at the time of sentencing. If there's any supporting documentation that may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. $3,500, 10% has been the bond, has been posted. Mr. Kocowski, your position on that?
No objection to continuing bond.
Ms. Weisenbach?
Yes, ask the bond to continue.
Bond will continue as previously said. Just to let probation know, we have a different address on the advice of rights form than we do on the information. And so that'll be provided to the probation department so that they get proper information for probation. That will be all. Thank you. Off the record.